Good day, everyone. My name is Victor Diaz, and I'm the Communications Manager at the ECLT Foundation. I'm delighted to be your moderator today. I would like to thank you for your presence and participation in this webinar. So today we're joined by two distinguished panelists from Ardea International who will share their insights and experience on how to put mandatory human rights and environmental due diligence into practice and what are the key concerns for the tobacco sector. Please note that there will be an interactive Q&A session at the end of the presentation, but you can also share your comments and questions in the chat box. So this webinar is also being recorded and will be shared on ECLT social media and e-learning platform later on. Our presenters today are Colleen Theron. She's the founder and CEO of Ardea International. She founded Ardea in 2010 to help companies understand how to meet their legal obligations for sustainability and business and human rights. And we also have Rory Oak. He's a consultant at Ardea International, and he has contributed to a range of projects relating to modern slavery and sustainability, developing practical solutions to embed human rights due diligence across supply chains. So without further ado, I give the floor to Colleen. So Colleen, thank you for being here. Could you please introduce us to Ardea International and to today's topic?
Thank you so much. Thank you for having us here, Victor. And it's an absolute pleasure to be with you all this afternoon. And thank you too for Rory being here. I'll let him say who is in a minute. Just really to reiterate what Victor has said, introducing us. Ardea is a specialist sustainability and business and human rights consultancy. We have particular expertise in modern slavery and forced labor. I think what is really different about us is that our team has legal expertise, but we strive at how we put the law into practice in a very practical way and a personable and principled way. And so our vision is really to lead business beyond compliance. And Rory, perhaps you just want to say a word as to who you are.
Yeah, sure. Thanks, Colleen. Hi, everyone. I'm Rory. I've been a consultant with Ardea for just under 5 years now. As Colleen mentioned, I also have a legal background, but my work is focused on various human rights due diligence and business human rights projects, including in agriculture and specifically in tobacco in recent years. I've also supported a lot of Ardea's due diligence training that we provide for our clients as well. Really looking forward to today's session.
Thank you, Rory. And just really, we are discussing tobacco today, but as a flavor of who we work with, Ardea works internationally and we work across sectors. We've done quite a lot of work in the tobacco sector, both at strategic and operational level. And I just really want to kick off today by asking all of you, what comes to mind when you hear the term due diligence? Perhaps you can put some responses into the chat for us. Are there any responses coming in? What do we think of as the term due diligence? Perhaps while we wait for people to consider this and to pop their responses into the chat, we can move to the next slide, Rory. So what we were asked to do today was really to give you some insights about putting the law into practice. As part of that, I think it's understanding why this is really important, what are some of the key concepts, and thinking about the impact of the new EU CS3D regulation and how that's also going to affect businesses, both large businesses, but actually also small businesses in the tobacco sector. So when we talk about human rights due diligence, what that really involved is actions taken by a company to identify and act upon actual and potential human rights impacts and risks for workers in their operations, supply chains, and services it uses. And there is a intersection between, I think next slide, Rory, there is, oh yes, no, there is an intersection between business risk and human rights impacts, which I'll cover after this. But we know that due diligence is something that is really fundamental, increasingly fundamental for all organizations to consider. And I'm going to cover a little more about that in relation to the law later on. But why does this matter to tobacco and to those of you listening? And I think that what we are seeing across all sectors and is really the spotlight being put on different sectors in relation to how they are conducting themselves responsibly, or if they are not, what is the root cause of that? And we are seeing increased attention put on companies' actual actions and what they are doing. And this lends itself to reputational risk, to operational disruption. We know that, for example, tobacco has been caught up in the American ports under the withhold release orders. And not only tobacco, but of course, a lot of other goods that are coming from China, particularly the Xi'an region. And so operationally, it is important to consider human rights and what your due diligence processes are. And of course, there is always the risk of legal liability arising from inadequate processes or inadequate operating procedures. And I also wanted to just pull out the point about audits and certification. So one of the things that we commonly see is that a lot of businesses spend a lot of money on audit. They might also spend a lot of money on human rights impact assessments. And in other sectors, there are certifications that are particularly used. And I just wanted to pull out the point that whilst these are important elements of due diligence, they need to be considered as part of a continuous due diligence plan and framework that is built. Because the reliance on just audit and certification will fail to protect workers. And we've seen this in a number of reports that have been made, and particularly studies in the last few years on just where the failure is of audit or certification to protect workers. And in a case study involving tea in 2022, a report was published where there was a list of 70 public allegations of abuse in the tea industry. And you'll see that incidents took place at supplier level, Sri Lanka, Bangladesh, Kenya, Uganda, and they were classified into 3 categories: rights of freedom of association, health and safety infringements, wage benefits, and living standard abuses. And why I've pulled this out is really just as a consideration, not only of the legal risk, but actually for those of you who are listening to consider how you have identified the salient human rights risks in your business. So that doesn't mean a human rights impact assessment at an operational level, but actually at a global level, understanding what your key human rights issues are and how you're going to address them in due diligence. And something that we've been seeing in other sectors, the tea sector has come under a tremendous spotlight of this, has been around issues of sexual harassment and bullying. And so it's just to be cognizant of what the particular issues are and how you might address them. And on the next slide, I have a picture from a visit that I made in Assam many years ago to one of the tea, or a number of years ago before COVID, to one of the tea growing farms. And this is just a picture of 2 of the workers who were sitting resting. What really struck me on that visit was 2 things. One was that the manager's office had a huge picture of one of the certification bodies painted onto their actual wall. The second was that the manager was protected by an AK-47 henchman. And the third is that even though there were laws in place in India to protect the workers, there was actually no enforcement of those laws, neither at a regulator, at a regulatory level, but neither at a operational level. And so what we also saw in this particular farm was that a lot of the workers were actually selling their children into factories because they just simply could not feed them. And I think we need to be cognizant of that when we start talking about what the law is and how do we put it into practice. We need to consider, from a business point of view, how you close the gap between your strategy and your operations. I call it an execution gap. It's the same that execution gap that exists with many regulators in relation to operations that happen within their countries. So turning to regulation, I think you'll be aware that there are two very critical international legal voluntary frameworks that exist as guidance for business to implement management systems and effective human rights due diligence. So this is the UN Guiding Principles on Business and Human Rights and the OECD guidelines, which set out also not only standards for human rights conduct, but also in relation to environmental conduct. Now, the OECD guidelines will set out the 6 steps. It's the next slide, Rory. Set out the 6 steps that are required for a business to consider when building its due diligence framework. And it is really a good framework for any business to consider how they are going to actually create their due diligence systems to reflect what the OECD guidance requires. Now, for those of you who are listening and paying attention, I think there are 2 aspects I want to just mention about OECD and the UNGPs. The one is obviously the very detailed guidance on how to set up a framework and what are the steps in actually addressing human rights and environmental due diligence. The next slide refers to the 3 pillars that the UN Guiding Principles is built on, which is around protect, respect, and remedy. And what is relevant, particularly for corporations, is the duty to respect under Pillar 2 and the requirement to remedy in the event that a business has caused or contributed to the harm of an individual. The duty to respect requires businesses to know and show how they are managing their human rights impacts. And it is a universal duty applying to all companies. Why it is particularly significant when we're talking about legislation is that the UN Guiding Principles, as well as the OEDC framework, are now being incorporated into national laws. And what that really means is that it's no longer a nice to have for a business to consider how it is going to build its due diligence, how it is going to manage its human rights impacts. Businesses and at different levels with different thresholds are now being required to actually consider these frameworks and actually be able to demonstrate how they are addressing their impacts. And that means from a practical point of view, for those businesses that haven't started thinking about what they have in place, to really consider an understanding or some help around knowing what it is that is going to have to be measured, the data that's going to have to come through that, and how you're going to report on it. And I'm saying that particularly with reference to the CS3D, because whilst many businesses here may or may not be caught by those thresholds, What we are seeing in relation to other laws that have been in place for some time, the Swiss law and the German laws, is that there's a very definite trickle-down effect where customers and buyers are requiring their suppliers to set out evidence of the standards that they are being required to meet. And all too often, there's a scramble at the last minute by businesses to try and pull together some information, particularly if they have to produce statements under Swiss law or other regulation, and not necessarily have the information to hand because they don't have the processes that underpin the statements. Now, this is just a diagram that actually I think Rory has become part of our virtually all our presentations, because it's been going, we've kind of been tracking the law since 2015 in this area around environmental and human rights and modern slavery reporting and due diligence. And what is really key here for me personally is that if you see the shift in the law and the rapid shift in requirements for both companies to understand both environmental and human rights impacts, it's actually, 10 years seems like a long period, but it's actually a relatively short period. And I am an environmental lawyer is my background. And when I watched the law shift in my time at practice in environmental issues and felt that was quite a rapid shift. But actually, in reflection, the law around addressing human rights and due diligence is actually taking on much more momentum, despite the fact it took a long time to get the CS3D passed. And for those businesses that haven't done a legal landscape review or an understanding of what laws they have to comply with, I would honestly suggest that to be a good starting place, so that you are clear about what laws require certain disclosures, and also to really streamline how you build your processes to enable you to report more effectively and better. Because we've worked with lots of companies who have requirements under the Norway Transparency Act, the California Act, the Canadian Act, the UK Act, the Australian Act. All of them have elements of requirements around risk and due diligence that are common, but there are particular intricacies in relation to each one that require some distinction. And for a business to get an overview and a sense of what that is important, because it will help them set out roles and responsibilities within the business on how to manage that and to create systems that are better aligned. So just going then to the CS3D, I think as you're aware, this is a piece of key legislation that has finally been passed by the EU on due diligence, for requiring companies to exercise due diligence around their actual and potential human rights and environmental adverse impacts. It is broad. It covers own operations, operations and subsidiaries, and operations carried out by business partners in the company's chain of activities. Now, Rory will speak a little bit more about that in terms of scope and some of those definitions. And we don't want to talk about how much changed from the first draft. I think what is certainly been acknowledged in many circles of experts in this area and companies, NGOs, is that there was a relief that it was passed, because there is a sense it's going to create a level playing field for many businesses. Now, I don't want to speak much about the Corporate Sustainability Reporting Directive. The only thing I want to say is that what I feel is happening in practice is that a lot of money and a lot of time and effort is being placed on compliance with the CSRD, and that is natural because of the reporting timescales. But I think there is a failure to understand that in order to report effectively, there is a need to undertake robust due diligence, and that should be taken into account. So if businesses are having to look at CS3D and excuse me, CSRD, they need to think about how they align their due diligence for reporting purposes. Just one other point on the law that I wanted to raise was the import bans. European Union has now approved a proposed EU forced labor regulation import ban. It's broader than the American one. I attended a very interesting discussion about import bans to the US by an expert in the US recently. And one of the things I took away from that was the extent that the US border control is investing in software to track where the source of products are coming from. And I think those learnings are going to be pulled across to the European Union regulators. So just bearing in mind, again, what traceability do you have? How can you demonstrate that the products, your tobacco that you are selling, that you are exporting has not been tainted by forced labor? I don't think I need to really mention this bill because of the fact that now our parliament is in recession. It was a private member's bill with an attempt to bring the UK back in level with the EU. If the Labour government does come into power, I think it's very likely that this bill will be reintroduced, knowing the person who actually put this forward into Parliament. And then just finally on legislation, something that I mentioned previously is that there are common trends. These are just a handful of them. Again, the practical takeaway from this is, what do you have in place? Are you aware of what you need to report on? What are you doing? And how can you ensure that what you are doing is aligned for all areas of reporting and due diligence? And I won't talk about enforcement penalties, but I just want to mention that actually there is a number of, I don't think it's on your slides, Maria. There are a number of enforcement measures that are being, that are now incorporated into supply chain legislation, which has significant financial penalties. So when we turn and we look at what is effective due diligence, I always feel that it's really useful to have a look at what previously the Non-Financial Direct Disclosure Act or legislation set out as being a requirement concerning effective due diligence, because they're really good markers for any business that is building their due diligence framework. Two of the things I want to pull out, and I'm going to talk about in a little bit more detail, is around corporate governance. I also want to mention allocation of resources. So a pattern that I've come to see over the last 10 years is that because there has been more media and more stringent laws and disclosure laws around climate change and environment, there's been a natural tendency in business to allocate much larger resources to those projects. And it is normal to see, you know, £250,000 going into an environment program, and then a trickle, maybe 20 grand, maybe a bit more, going into how to address human rights side of it. And I think that that's going to have to require a shift. When you look at the requirements under the CS3D, when you look at the potential for reputational and legal liability, that allocation of resources, and that might also mean internal resources, getting the right people to work with you, is going to have to shift. And that will come down to the top management and the culture of the business. So why carry out due diligence? We've probably talked about this a little bit in relation to reputational risk, preventing negative impacts, meeting customer requirements. I think also looking at how you improve your relationship with your stakeholders, because I think all too often with due diligence processes, there is perhaps the forgotten element of getting feedback from stakeholders within and externally in the business to help address and improve your systems. So in relation to the directors, governance, leadership, I just wanted to pull out something on directors' duties. It was met with some disappointment that the previous reference to directors' duties in the CS3D had been removed, because there had in previous iterations been an explicit duty of care that was included for directors of EU companies, and that would make them really responsible for overseeing the due diligence requirements. Now, that's been removed from the text, but the CS3D still requires that adverse impacts are considered and assessed at board level. And there is always still the requirement for boards to consider how they align new obligations with their duties under domestic law. And those duties are both fiduciary and statutory duties. And I think what the feedback I've had from a number of workshops and briefings that we do at a director level is that directors very seldom get the opportunity to really have the space to consider these things and really debate and think about the long-term and best interests of the company. And I would suggest that for those of you who are in a position to influence or consider how to influence the board, is that there are two things to consider. One is look at the governance structure, and that will mean setting up accountability within the business. And part of that is reporting to your board of directors and ensuring that the information that they get is timely and appropriate, and also that they are properly skilled. So in the training we've done in the last 8 months, I think that there's been a real insight from our perspective of just how many boards still lack real ESG skill sets and very little around actual human rights. And so, these are considerations to take into account when you want to think about what upskilling does a board mean if you're an HR manager, but secondly, what information do they need reported to them to be able to allow them to make appropriate decisions. And as part of your governance structure, you want to set out appropriate roles and responsibilities. So really breaking down what is required in respect of the different roles within your business. We run a end slavery training program, also one on child labor and business human rights. And within those, there are checklists for roles and responsibility, and it's quite a useful guide to have for a business. The other point I wanted to make is that BS 25700 is a British standard guidance on modern slavery. It has some very useful guidance on roles and responsibilities. I'll put the link in the chat. I was on that committee developing the standard for 3 years. That standard is now being developed in an ISO standard, and I've joined that committee. So it's very useful from a guidance perspective. And then I think that brings me to the end of what I was going to share, Rory, and just hand over to you now to talk more about the scope of due diligence and particularly discussion around risk and remediation. Thank you.
Yeah, thanks, Colleen. So yeah, looking at the scope of human rights due diligence and which companies have obligations and how far beyond the company's own operations they need to extend that due diligence. I think the first thing to cover, and some people may already be aware of this, but is the companies that the CS3D applies to. So it applies to companies with over 1,000 employees, over 450 million euros net turnover, and importantly, it also applies to non-EU companies with more than 450 million euros generated within the EU. One final point I wanted to make is that there are no longer any provisions in there relating to lower thresholds for higher risk sectors, which would have applied to agriculture and tobacco as it was in the previous draft. So really the key points to note in terms of the scope of the directive are that due diligence can extend to non-EU companies, And also the fact that, I'll come back to this as well, is the fact that parent companies are expected to conduct due diligence over their subsidiaries. So looking at that scope of due diligence in a bit more detail, it needs to apply to the company's own operations, their subsidiaries, and also their business partners. So that means that this approach needs to apply to the company's global value chain, essentially. And on the next slide, I'll look at the value chain definition in a bit more detail. So again, going back to the law, where the due diligence under the directive extends to business partners, this means it covers your upstream value chain. So that's your company's suppliers and the chain of suppliers beyond those tier one or direct suppliers that a company has, but also some of the downstream value chain. So it includes the directive specifically highlights like distribution, transport, and storage of products. So it isn't limited to just your supply chain like some other human rights due diligence or reporting legislation is. So it's got a very, very broad scope. And another important thing to mention is that the employee count, I think Colleen touched on this, the employee count and the thresholds are quite high, much higher than they were initially proposed to be. So it maybe won't apply to as many companies as initially expected, but companies that supply products, such as selling your tobacco to a large company that's in scope of the directive, those companies are going to have some burden placed on them because these companies will inevitably be requesting data and evidence of actions from their suppliers in order to discharge their own obligations under the directive, because they need to be completing checks and monitoring their business partners, which maybe include, quite small companies within the value chain. One thing I just wanted to pull out was looking at other national legislation, because lots of the companies that fall within the directive, the scope of the directive, will also fall within the scope of, say, the German Supply Chain Act. And they do include different definitions of supply chain and value chain. So it can get quite confusing in terms of the scope of due diligence. You can see that the Netherlands bill includes a very broad value chain scope, covering the whole of a company's activities, its supply chains, and its customers, both upstream and downstream. And then the German Supply Chain Act uses the term supply chain, which sounds different, although it's still very broad because it includes all steps required to produce products and provide services, including everything from raw materials to delivery to the end customer. So there's lots of different terminology being used and some kind of overlap and confusion around the terms supply chain and value chain or chain of activities. So it's just really important for companies to look at the details of, look into the detail of the legislation and see how broad their due diligence needs to be to comply with these laws. From a kind of best practice perspective though, we would of course recommend that all businesses should be seeking to engage at least their tier one or direct suppliers as a minimum, but also going beyond tier one to map the human rights and environmental risks associated with suppliers further down the supply chain. Companies are now more than ever expecting their suppliers to cascade their own standards down, for example, by saying in your code of conduct that all suppliers need to apply the same principles to their own suppliers down the supply chain, and that they need to uphold those as minimum standards. To see an example of best practice, you can look at this. Marks and Spencer's have this interactive map that's online, and it shows it's primarily focused on modern slavery risk, I think, but it shows where the suppliers are, the product or supplier or service that each supplier provides to them, as well as information on the number of workers and the demographics of workers at each site. So it really shows that they've got a very high level of visibility throughout their supply chain. And when it comes to a tobacco supply chain, I think it's also always worth highlighting the fact that these principles apply beyond just the farm level. So the OECD guidance that Colleen mentioned earlier, that covers agricultural upstream and downstream actors from the supply of the agricultural inputs like seeds and fertilizers and things, as well as production, post-harvest handling, processing, transportation, and everything up to and including distribution to the customer. I think this is a really key point to bear in mind, because lots of companies develop their due diligence frameworks rightly with a lot of focus on the farm farm level when it comes to human rights due diligence. But a lot of companies have been flagged by labour inspectors and regulators in America and the UK and Europe, not just in relation to the farm itself. So actually in the factories and the warehouses, even support services that relate to office operations, things like your cleaners and rubbish collectors and things like that. So I think it just shows that companies need to apply these principles not only on the farm but also the steps in the supply chain that surround the farm or follow on from that in the kind of in the value chain process. So before I move on to looking at the due diligence cycle in a bit more detail, I just wanted to share this on the timeline of implementation for the CS3D. So member states will need to adopt the directive into national law by 2026. And then in 2028, the CS3D is going to apply to an initial set of very large companies. As you can see, it's companies with over 3,000 employees and a net world turnover of over 900 million. And then finally, by mid-2029, that's when the provisions will apply to all of the companies that fall within that scope of the directive. So the 1,000 employees and 450 million annual turnover. So going into the due diligence cycle in a bit more detail, the first step, as you can see here, is embedding responsible business conduct into your policies and management systems. To give that a bit more context, this is one of the foundational principles of the UN guiding principles, and it's also reflected in the OECD guidance and due diligence legislation that we're increasingly seeing, following the same principles set out in this guidance. So this requires companies to adopt a policy commitment to meet their responsibility to respect human rights, and then underpin this with effective processes. We can talk about, when we talk about what good policies that are backed up by processes, these are some of the things that I would say are quite important to consider. So aligning your policies to applicable legislation and international standards, having clear processes for monitoring and enforcement, a clear scope of application. So if there's policies that need to apply to just all your employees or your suppliers as well, that needs to be made really clear. And then regularly reviewing those policies to make sure that the content is adequate and up to date, and making sure that policies are signed off by an accountable manager of senior management. They're not just published, printed, and left alone. And then a clarity of roles and responsibilities and kind of goals and metrics that underpin that policy to make sure it's being properly implemented. And that's quite a kind of theory-based look at embedding policies into management systems. To give a more practical example of where a company has failed to implement these things. Some people may have heard this story. It was a very big one in the UK. There were allegations against Boohoo, a fast fashion brand in the UK, which included basically adequate protection for workers at the height of the COVID pandemic in their factories, and issues around pay and the treatment of workers, which were essentially labelled conditions of modern slavery. And then there was a legal opinion that was commissioned after this incident, where the legal opinion basically said that Boohoo had considered their human rights impacts and they had commitments in place, but they failed to follow up with clear policies and processes to demonstrate that they had actually responded to these considerations. So they have actually more recently faced legal action from their shareholders in relation to this case, because essentially the bad publicity from this happening had a massively detrimental effect on the share price, as you can imagine. But it does help to highlight the importance of not just having policies in place or saying that you're going to do things in a certain way. It's important to actually underpin those with strong processes. So sorry, just losing my slides there. Yeah, so when it comes to having a code of conduct, which is one of the most important kind of policies to set out a company's commitment, it's obviously a really valuable thing in the context of due diligence because it sets the company's expectations for employees and third parties. it establishes the values of an organization, and it also gives you the basis for compliance with a set standard to be monitored. On screen here, we've just got an ARDIA white paper on the value of codes of conduct and how to improve them. So you can have a look at that on our website. We'll share the slides afterwards, so you'll have the link as well. But provide some quite useful guidance on how to develop a strong code of conduct and why they're so important. And best practice when it comes to a code of conduct is similar to any other policy. So I won't go through all of these, but there's probably additional thought that needs to be given to how the code of conduct is communicated to people, especially in a global supply chain, if you're expecting suppliers to adhere to that code of conduct, as well as how your roles and responsibilities are established, as Colleen mentioned. So board level oversight and clearly communicating the policy to your suppliers and to your employees, and also clear responsibilities for managers. That might be managers who need to internally monitor whether people are complying with the code of conduct, or it might be your procurement teams or anyone who engages with suppliers to ensure that they're adhering to the principles of the code. And the next aspect of due diligence to consider is identifying risks. So this is that second step of the due diligence cycle. I wanted to start by just following on from what Colleen mentioned earlier, the fact that human rights due diligence is this process of an enterprise proactively managing their actual and potential human rights or environmental impacts. And when you're looking at that, it's really important to think about the fact that human rights due diligence is about considering the impact or the risk to people, not looking at risk to business in the first instance. So it's applying a different lens, a lens of risk to people and not risk to business as your starting point. And there is, of course, often quite a lot of overlap between the two. If we take the example of this gender-based violence case study from Ergon, the risk to people is quite obvious, or the impact to people is obvious. It's discrimination, and that's going to have an impact on the individuals, the families, and that's quite an obvious piece. But there's an overlapping risk to business, as there often is, because of legal liability, potential reputational impact, maybe even operational disruption, and then, of course, a kind of customer relations issue for a company selling to even whether it's another business or whether it's to consumers directly. And to share a case study on an example where a company has failed to identify risk despite having processes in place. This is a case relating to coffee in Brazil, which is quite useful. In 2020, 140 workers were rescued from slave-like conditions on a coffee plantation. These plantations actually supplied coffee to these big international brands like Nespresso and Starbucks. And it was after an investigation confirmed that this issue was they were able to verify this issue, and workers had to be paid compensation for the lost wages that they'd suffered. What was quite interesting was the responses from the companies and their auditors. So they both responded saying that there had been this audit and verification program in place, which was in many ways a relatively mature system. And it actually included an in-person visit of the site just 2 weeks before the findings of these conditions on the plantation. So this really shows that even though they had an audit 2 weeks prior, these processes can still miss risks when they're the only tool that a company uses if they're used in isolation. And companies can avoid missing these negative impacts by using multiple methods of risk identification. Of course, different methods will be appropriate depending on the sector and the context. But this best practice example here from the Centre for Child Rights and Business it's quite a useful illustration of how you can have multiple methods used in conjunction with each other to have a system that includes things like worker voice and stakeholder engagement, and that will lead to more credible results and ensure that companies aren't missing impacts where a one-off audit or a site visit might miss those issues that are actually happening on site. These are just some considerations to keep in mind when approaching risk identification. So mapping supply chains. Ooh, sorry, having real issues with my slides. Yeah, mapping supply chains and understanding where risks might arise. So again, beyond the farm context, looking across the whole value chain. Stakeholder consultation throughout is really key, and also links to understanding the root causes of human rights risks and impacts. That's a really important aspect to be able to take proactive steps to address risks down the line and not just being reactive when something arises. It's also very important to make sure that there's documented evidence of the actions that you've taken in due diligence, because that's going to be important for reporting publicly. If, for example, under the due diligence directive, a company has to do that, but also internally, as we looked at earlier, having that effective governance structure and making sure that the appropriate information is passed up to the very top to board level. It's being able to then carry out those ongoing checks and monitor the effectiveness of due diligence and having a real systematic approach to assessing risks. And the final one here, or the one in the top middle there, is prioritizing actual and potential impacts, which I think is worth looking at in a bit more detail because it's a slightly bigger topic, but it's a key part of this cease, prevent, mitigate stage of the due diligence cycle. So a risk gets identified by a company and they then need to respond in this third step of the due diligence cycle. And when it comes to doing this, one of the most challenging things for companies often can be prioritizing the issues. If you've got, often if there's a massive company with a very developed due diligence system, they're going to be spotting lots of issues. That's a sign that their due diligence or their risk identification is actually working. And then the company, they need to know when they should act, but also how they should prioritize issues. So to make sure that the most severe issues are addressed as a priority over less significant things. So as you can see, the UNGPs state that companies need to first seek to prevent and mitigate those issues that are the most severe or where a delayed response would make them irremediable, so impossible to make right, essentially. And this involves assessing them against these factors. So scope, how many people could be affected, what the scale is, how serious the impact would be, irremediability, so whether a remedy could be provided to restore the victim to the same position that they would have been in had the impact not occurred. And then also an important consideration is the link to business. So whether that business caused or contributed the impact or if it's directly linked to it. And looking at that linkage aspect in a bit more detail, when it comes to assessing when companies should be taking action to cease and prevent human rights impacts, the UNGPs give this cause, contribute, directly linked framework. So causing is where a company directly causes an impact. This is usually quite clear, where a business's own actions have led directly to an impact. And then contribution is often where an impact happens via a third party or a company acting in conjunction with another entity, like a supplier or business partner. And then direct link is where the company, even though they haven't caused or contributed it themselves, the impact is directly linked to its operations through a business relationship. So if a company has caused or contributed to a human rights impact, they're expected to cease or prevent whatever action is causing the harm. And then if it's linked to a harm through a third party and can't directly actually stop that action causing the harm, they're not able to do that. They're expected to build or use their leverage to mitigate the harm. So that will be, basically working with your supplier to try to make sure that they restore victims and change working practices to make sure that this kind of impact doesn't occur again. I know that's quite a lot of information on that slide, so we're going to share these afterwards so you can have a look at this table in a bit more detail. Don't have time to do it justice now, but I think the key thing to remember is that, you know, there is a recognized framework to follow when assessing whether and how issues need to be addressed, which, you know, companies often find that quite challenging, understanding the extent and the limit of their duty to respond to issues that they identify. And that leads us into the remedy aspect of due diligence remediation, which is this kind of final step that sits outside of the due diligence cycle. This is also something that's covered in the UNGPs and also reflected in the due diligence legislation. All of this mandatory due diligence legislation that we're seeing coming through has a reference to remedy and grievance mechanisms. And I think the most important thing to flag here is that this piece at the bottom here. So when it comes to remedy, the aim is to restore individuals or groups that have been harmed by businesses' activities to the situation they would have been in had the impact not occurred. And then where this isn't possible, companies should consider compensation or other forms of remedy, which we'll look into in the next few slides. Just some key things to consider when you're addressing remediation. It's of course important to have effective grievance mechanisms, which actually, well, I was going to say could be a session in its own right, but we actually have a training coming up in the next week, I think, isn't it, Colleen? Our training remediation workshop.
Yeah, that's right. I'll pop it into the chat actually.
Yeah, we can share the link to that. And yeah, engaging communities is also a key aspect, which again goes back to that stakeholder engagement piece and ties into also this consultation and consent aspect of the remedy process. I think practically having effective investigation and remediation plans are of course important to make sure that your remediation leads to suitable outcomes for affected rights holders. And then the other principles are really those that apply just across all of due diligence. So you're monitoring and reporting, having proper capacity building in place, and then your communication and transparency. So both to people who might be affected, as well as communication internally and publicly, if that's necessary as well.
And actually, Rory, is it worth also just adding there when we're talking about remedy that, you know, what we seeing as useful is having a remediation protocol actually documented with, you know, a really sort of practical steps that an organization should consider, and also explaining what is meant by effective remediation and what is effective grievance mechanisms, because I think there's often a misunderstanding that just a simple whistleblowing line is part of a grievance mechanisms, but in fact that's only one aspect of it. So I know, Rory, you were going to talk about the process, but just to flag that sort of remediation protocol side of things.
Yeah, absolutely. And I think, yeah, this was just how we kind of narrowed this down into the real essential aspects that a company needs to have in place. And like you say, that formal process to engage in remediation is really important. But also, I think offering support to suppliers and other business partners. I think a lot of companies kind of take the approach of having their own house in order and making sure that they've got processes internally, but you know, as well as just having corrective actions and things like that for suppliers, it's important to actually offer support to them to improve their practices. You know, we're increasingly also seeing that it's not an adequate response to just cut a supplier off. So, you know, companies are expected to work with that supplier, provide any support like capacity building or practical support that they can. Otherwise, companies are still finding that there's big reputational consequences for just ripping up a contract and saying we're not going to deal with that supplier anymore, when the result is that people are still left in a bad situation in terms of their labour rights, for example. And yeah, an effective grievance channel needs to be in place. I think another thing to note, I don't think we'll cover it here, but the UNGPs provide a really useful set of effectiveness criteria for companies to review their grievance mechanisms against, and see if they align with best practice. So yeah, those are really the kind of minimum requirements to get started with developing a remediation process. But yeah, that previous slide has a lot more in terms of best practice considerations that companies should be looking to build in. One thing that's quite useful is that we've seen quite a lot of legal cases brought against companies in recent years, and where they've reached settlements, and those settlements have been public. They do show some of the different forms that remedy can take. So you can see from these examples here that it's not just a case of financial compensation. They're actually quite varied. They include things like changing the company's policies and processes, strengthening or just providing a grievance mechanism that wasn't there before, employment of people in new roles. That's things like these safety marshals. That's an example from agriculture, where there was a high rate of I think gender-based violence and sexual harassment. One of the actions that they took was to put safety marshals in place in a new role, as well as also providing training. So that's could be providing training to internal staff, but also to farmers to provide them with long-term sustainable incomes and alternatives, and then community support initiatives as well. So all of these have actually been part of settlements in legal cases where companies have settled with, I think these are actually agricultural as well. So they've settled with farmers, and these are the kind of actions that they've taken. And they just really highlight how wide the range of actions can be, depending on the context of the business and the human rights issues at play. I think often people think of remediation as just being compensation, just providing compensation where something's gone wrong or someone hasn't, because it might be something related to their salary or something like that. Being withheld wages is quite a common issue, but when you're dealing with some of the more complicated issues like sexual harassment, some of these slightly different approaches might need to be taken. And I think when you think about, whilst these are things that have come up from legal cases and settlements, they do actually provide a useful guide for what constitutes an acceptable remedy. So companies can actually apply these principles and use these range of actions as a good, to give a good steer to the type of actions they might look to take when tackling remediation. So I'll now hand back to you, Colleen, to look at monitoring and tracking effectiveness.
Yeah, thank you, Rory. So a critical element of due diligence is, how do you track your implementation? How do you track and measure your results? And then how do you communicate these results? So one of the things, again, I'm sorry, back to the other slide, Rory. One of the things that I think have become a lot more aware of, and this is arising either from practice or from disclosure requirements, is that many companies have things in place, actions, or they identify and assess, but actually monitoring the effectiveness of a step that you've put in place and measuring the results, and then ensuring that that's appropriately verified information caught in data to report on, is still in quite a relative immaturity for most companies. And we see this also particularly when we look at audits that have been commissioned or human rights impact assessments. Many businesses are not thinking about the cycle as a whole when they are looking at identify and assess, because when you actually go and look at the results of your audits or your results of your human rights impact assessments, from an internal perspective, there will need to be a team or a person, depending on the size of the business, that is able to actually consider what the information means and how the business is going to act on it. And what you don't want is 5 or 10 impact assessment reports and not an understanding on how you're going to act on it. As part of your overall planning to think about monitoring and responding and disclosure, these things should be put, or these things should be accounted for in your cycle. Now, one of the things that we thought we would share with you, this isn't a tobacco example, but it does provide a really good example of what I've been talking about. So a US client had contacted us to help them identify the social non-compliance issues that were pulled out in a social audit for their business, Asian-based factory and Singaporean-based organization. And what was particularly interesting is that, for example, in this audit, they identified that identified there was no drinking water testing that took place. So the client's managers then commissioned a water report, and the report indicated that the water test had not been, that they hadn't tested it, they had this report. But then a subsequent follow-up showed that the water test had not been reviewed, and also that the drinking water was therefore unsafe. So they had not moved any further forward, despite the fact that they'd now commissioned a water report, did some more testings, and even commissioned a further social audit. So that is a good example of ineffective monitoring on the effectiveness of actions. And actually, as part of this finding, what we spent some time considering was what were the root causes of the non-compliances that had been identified in the social compliance audit. And as part of that assessment, we did some interviews with the managers and with workers on an anonymous basis to get a better understanding, not just, so this was a water-related example, but from a worker perspective, get a better understanding of the culture and some of the more systemic issues that existed within this Asian operation of this US-owned company. And it was particularly interesting to do that because I think it showed or revealed a number of things. And I think these things are true of companies across all sectors. First of all, there was an inappropriate governance structure. And whilst there was a corporate understanding at head office that things would be done in a certain way, that wasn't followed through in culture and an understanding. Secondly, there wasn't necessarily an understanding also of what was driving auditing and what was sitting behind these requirements. So again, for businesses, this goes to ensuring that your parent company, with its policies, with its objectives, is making it really clear to its subsidiaries and to its operations why certain standards have to be set and certain requirements should be met. So that was one element, was this kind of governance and operational gap. I think the second point was that the ineffectiveness of the social audit was very clear in that a lot of there was very much a tick box approach that was taken to solving some of the issues that had been identified. So there were no policies. Could you write one? And the kind of policy we saw, or policies that were drafted, were not dissimilar actually to some we've seen in other due diligence we've undertaken, which is just very light, a response to this is needed, and therefore it's a bit of a tick box. And certainly nobody beyond who drafted those reports or those policies would have understood what they even meant. So that was the second point. I think then the third point was that no gender consideration had particularly been given to the opportunity to raise complaints. And what I mean by that is that, there was a box that had been a suggestion box set out, and any worker was entitled to put their suggestions into that box. Where that box was placed made it very difficult for a woman to want to actually if they ever wanted to raise a complaint, because it was very close to the men's loos. And this is particularly true in a culture where women in that area are more subservient to men in any case. So that was another thing that sort of, highlighted issues to us around the understanding of your workforce and what is required by them. And then there was a real sort of bullying and harassment culture. And that was something that had to be dealt with carefully and over longer term. We've got on the slide, a Plan, Do, Check, Act cycle. Now, for those of you who are familiar with environmental standards and in fact doing environmental quality issues, ISO is often the given standard, whether that's 9001, whether it's 15001. There are very many different ISO standards, but they all follow the same pattern. And that pattern of Plan, Do, Check, Act is not dissimilar to the OECD 6-step requirements, because it still is indicating continuous improvement, and it is still requiring that there is an engagement and a movement in respect of each aspect that falls within that cycle. What we subsequently have done is we've developed a social management compliance system, particularly for operations, where a business can use that as a means of ensuring social compliance. But we've built it, whilst we've built it in the framework of Plan, Do, Act, Check, Act, it marries up to the OECD framework. And that means, because of the way the legislation is going, you can start closing that gap that I spoke about at the beginning, the execution gap, where you have a strategic requirement and an operational need, and how do you bring the two together? So, so those are just some thoughts around monitoring and capturing and understanding what issues are, and then capturing a mechanism that's effective to be able to act on it and to continually revisit it. So I think that's also something that we see as a pattern, is that things are started, not completed. The data then isn't filtered through to the right places, and you're back to square one, really. Another element that I just thought would be useful to consider when we're talking about monitoring and performance, it is commonplace, or growing commonplace, that supplier codes of conduct that Rory mentioned are being issued to suppliers, and that might be aligned to a contract which has certain terms and conditions, and which will require the business who receives the supplier code of conduct to tick a box on the contract to show that they've received it, and they will therefore stand by its principles. Now, that is acknowledged. It's acknowledged that that's a means of ensuring that the principles of a business are shared with the supplier, and they take some responsibility by acknowledging what they are doing within their contracts. What is particularly interesting with CS3D is that there is an introduction of buyer and shared responsibility. And I think there are very few companies that possibly understand the implication of that and what that really means in practice when we talk about shared relationships. And I feel that it's something that's going to need a lot of education, both for in-house lawyers, both for external lawyers, and for companies to get that concept right, where there has always been a tendency to pass risk on through contracts. What we are suggesting in this slide is that most companies don't often do a very deep analysis of their terms and conditions of contracts or their contractual requirements. And we would suggest that a revisit of key SLA frameworks or supplier contracts are undertaken, just to ensure that you have proper arrangements in place about end of contract requirements, how monitoring human rights will be undertaken, whether within the lifetime of the contract there are KPIs to monitor human rights risk, whether in the instance of an issue, a business needs to report a human rights issue, and how will performance be managed. Now, just two more things in relation to contracts. When one looks at the obligation to report on human rights issues, I think we've seen that particularly in the relation to actually the use of third-party agencies and the reliance on the agencies to bring in subcontracted workers into your work stream or into your operations. Where those contracts and requirements have not been necessarily reviewed, properly understood, there is often not sufficient contractual requirements set out between the two parties to allow the contracting party to perhaps audit the operations of a third party, an agency. This is particularly highlighted in a case in the UK called Operation Fort, where a criminal gang had actually infiltrated a recruitment agency, and ultimately they were paying themselves money for people that were being trafficked into work. The failure of a business in that circumstance to be able to audit that particular agency would mean that you wouldn't get the visibility. And actually what you want to be doing is developing recruitment protocols where there is a requirement as part of your contract terms that the business would report in a certain way if there are particular instances. Now, I'm not sure a one-size recruitment protocol fits all. We've recently done one in the sports sector. It had a very different flavor to one that we'd done in the tobacco sector. And again, for these kind of protocols and policies to work, one needs to think about the context in which they are operating and what will be practical in relation to reporting or auditing or checking. Another point I wanted to raise is about poor performance. The shift towards shared responsibility is also bringing a shift towards responsible disengagement in industry. We didn't see that 5 years ago. You know, it was much more par for the course that where a supplier was failing, where there were constant issues around child labor, that the ties would be cut with that particular supplier. But the shift towards responsible disengagement and actually something Rory also mentioned, supplier engagement, capacity building is changed rapidly. And there is much more of an expectation that a business would look at how it would responsibly disengage. Now, I'm not saying that means you tolerate all forms of child labor forever, but actually you build in a tolerance model. And I remember when I was negotiating contractual warranties and indemnities with lenders when I worked in the city, what was often an argument was default clauses and the timing around them. But it's an interesting principle because a default clause allows for a correction, a time for correction and time for opportunity to fix something. And perhaps applying those kind of principles is useful when you're thinking about how you will monitor and manage poor performance of suppliers. The very last point I want to make on performance and contract management is that we are very excited to be looking at a partnership with another South African. I'm South African, if you wondered what my accent was. Rory's not South African, but we are working with a South African lawyer who has a very interesting concept around creative contracts. We are putting together a pilot for the ability for organizations who participate to be able to provide worker contracts as well as e-learning training on child labor through a phone. Any phone, could be a smartphone, could be another phone, but there are two elements to that. One is accessibility, one is learning. But the really interesting aspect for me is how we can connect completion and acceptance of those contracts, completion of the training to your overall due diligence programs and how that might look in terms of reporting and monitoring. So if that's something you'd like to hear more about, we are discussing this with ECLT. We've done a demo with them, but we will be following up on that. And if you want to know more, please just drop Rory or me a line on that. And then finally, just to come down to reporting. Now, reporting is a really interesting area because, of course, reporting doesn't just cover internal reporting, it also covers external reporting. So we look to the next slide, Rory. There is, again, some useful guidance on internal reporting in the BS standard. I've put the link in to the chat for you. Sorry, Rory, if you go back. And we've talked about this also in the context of governance structures. So from a practical point of view, businesses should consider internal reporting, what that looks like, what's needed to be fed in terms of information to a hierarchy of management and leadership. And then, of course, external reporting, which is firstly imposed and increasingly imposed by legislation and standards, voluntary standards around reporting. So, environmental standards, frameworks like the GRI, and certain particular requirements around who should sign those statements, what the accountability is, when they should be produced, if they should be continually updated. The other element of external reporting is that, of course, it informs stakeholders. Now, I just want to make a mention of this again, or something to think about practically. There is a growing backlash against greenwashing, sports washing, youth washing. There's so many elements of washing. I don't know if you can think of any others, Rory. Those are the three that come to mind.
Blue washing is the latest one I've heard.
Yeah.
Social washing.
Social washing. I mean, any kind of washing, it's in there. I think the backlash or the interest about that is that people are fed up of claims that are made that are not substantiated. The challenge for business on this is finding a line of reporting that actually gives the opportunity for its stakeholders to see it being transparent and accountable, but not risking misrepresentation or potential liability for stating things that actually they cannot meet. So setting out objectives where there is no resource, there is no budget, there is no internal expertise, and there is no time, that is just a measure or a recipe for disaster. And I would also say within that, there is going to have to be a re-education for lawyers on this, because whilst Rory and I are lawyers, we've worked around supply chain due diligence for a long time. And that means there is an understanding around supply chain challenges. And, lawyers are trained to be risk adverse and they are nervous about what is put out there. But when you look at the CS3D regulation, when you look at CSRD, there is the shift towards how companies demonstrate how they mitigate risk. And that means you're going to have to be transparent. So again, an area to consider, again, getting it right, ensuring that what you are able to say is a statement that you can make, knowing that your policies and your procedures can underpin that. And actually also accepting that it's okay to talk about a journey, and it's okay also to pull out things that case studies where things have gone wrong. I mean, Tony's Chocolonely does this incredibly well, where they specify the number of children found in their supply chains, but they can do that because they've got very strong measures on how they get to address that. And then just sorry.
Just to add there, the other other sort of development recently that we've been tracking is the greenwashing directive, and the fact that includes claims around social characteristics of products. So if it's just for companies that are selling to consumers, but it is a big kind of crackdown on companies that might be doing the opposite of what Tony's Chocolonely is doing and saying we've got no human rights issues, no child labor, everything's great. Companies could find themselves. I think the focus since that, because it's called the greenwashing directive, lots of people just associate it with environmental and carbon claims and things like that. But there is a big social characteristics element to that, which is going to include human rights as well. So, definitely a shift from what we've seen in recent years with things like the Modern Slavery Act in the UK, where, to be honest, a lot of companies make promises and commitments in their statements that they never actually meet. They publish them year on year with the same commitments and promises in there. That's potentially showing that in Europe, at least, it's moving towards a situation where companies won't be able to do that anymore because there's a big liability risk there.
Yeah, thank you for sharing that, Rory. And I just think that, what you're demonstrating is what we've been talking about, is that whilst laws have been in place for some time, it's this rapidly evolving landscape where, the requirements are changing so quickly. And actually, for a business to be equipped, to be resilient, to be to understand what its risk is, to meet that, there just is going to need to be a shift. And we haven't talked much about culture today. I meant to add that into when I was highlighting directors' duties. It's something that we debated for a very long time in the BS standard. I have to say, we haven't quite got there yet on the ISO standard, but after this week, where it took 3.5 hours to do one definition, I might have lost the will to live. But that whole sense of culture is really key. The culture of a business is set, and the tone is set at the top. And that needs to carry through into the business in terms of respecting human rights. And I think all too often, when we talk about the duty to respect human rights, companies will tend to go to their supply chain and to perhaps the issues around tobacco, child labor, or forced labor. But actually, there is a requirement to consider your own organization. What are your salient human rights in your own organization? Is it health and safety? Is it discrimination? Do you have do you have a diverse board? Do you have an opportunity for women to grow in and consider what roles they might take? Tobacco is difficult because in warehousing, it's very difficult having to pick up huge amounts of bales, and it's often a very, men tend to need to do that job because it's too heavy for women. But there are other places in the business where they might be grown. So I do think culture is a really critical element and a difficult element, and not just for tobacco, but for many sectors. I mean, sport is another area where we see, not many women who are in the sporting boardrooms and the governance side of things, and the need for shifting around that. And then if we go to the final slide. So how do we accelerate implementation? So these are just some ideas, some of the things that we've thought were useful to share with you. I think documenting your current regulations is key. I don't think we've ever done a legal landscape review for a company where they haven't been slightly surprised at what laws they had to meet, or the deadlines around that, particularly around human rights and modern slavery. You need to do a gap analysis. You need to understand what is in place and what isn't in place. We've just developed a human rights maturity due diligence assessment, which can help that process of identification, what you have in place and what you don't have. Your due diligence needs to align to international standards such as the UNGPs and the OECD. We spoke about that earlier. Data and evidence is a really key aspect now, particularly if you're looking at CS 3D, and where those crossovers are when you're looking at the data points. What due diligence do you need to be able to fulfill the disclosures? Cross-functional working is critical. Setting those governance structures, setting out reporting, setting out the opportunity for people to work across the board so they're not in silos. and establishing the lines of communication. So I think that brings me and us to the end of our presentation. Two things I want to share in the chat. One is we are actually running a CS3D webinar tomorrow with very different speakers giving very different views on human rights due diligence. You are welcome to join that. It's free. The other element that I thought would be interesting for anybody that is attending today, and if you are based in London or coming through London, we are hosting our second annual Modern Slavery Conference. We have some incredible speakers. We've partnered with a number of our clients. It's under Chatham House. It's very practical. It's built around a workshop, and there are early bird tickets. So I'm just going to share those two things with you. And just to say thank you again to ECLT for this opportunity. Thank you, Rory, for your input, and we look forward to questions now. Thank you.
Thank you so much, Rory and Colleen. So yeah, we have some questions. One is from Cephas. It's on the chat box. I guess you have access to it, Colleen and Rory. But it's with increasing need for increased agricultural productivity in development countries. How can due diligence in human rights assist in the eradication of hazardous child labor, especially in sectors such as tobacco?
Do you want to have a go, Rory, and I can come back?
Yeah, sure. I think the eradication of all forms of hazardous child labor kind of suggests the total elimination of child labor risk, which realistically we're a long way off of that, especially in developing countries, and it's dependent on a lot of other factors and root causes that are kind of outside of a company's control. I think the target was 2025, was it, Colleen, for the ILO and SDGs total eradication of child labor, which we're 6 months away from 2025, and there's still a lot to be done. But I do think the proper kind of implementation of due diligence, as well as collaboration with other organizations like industry initiatives and organizations like ECLT, I think that is the best tool that companies have at their disposal to address child labor risks, especially if you're looking specifically at the most hazardous forms of child labor. It's having those systems in place to be able to identify it on farms, knowing the right steps that need to be taken to address it and to address root causes. To answer your question, I do think that due diligence in line with those best practice standards is essentially the best tool that companies have. And in tobacco, they've started moving towards that process with things like STP and developing a kind of system where farmers are visited and corrective actions are given out and things like that. But yeah, I think it's kind of the best tool that companies have is due diligence, really would be my answer.
Yeah, I would agree with that. Rory, for in the first place, for business to understand, why are children participating in hazardous work, and how, and also, when can children be involved in the sector? I think that there's a growing concern globally about the fact that children of farmers are not interested in staying in farming. They're moving out of it. And that is a threat across all supply chains to supply, whether that's agriculture, tobacco, anything else, because you need the next generation to be learning the skills. And I think there probably needs, this whole thing goes down to education and support to farmers about what is acceptable, what isn't acceptable as the bottom line, and those companies that are sourcing to really do the capacity building and to do the monitoring and to do, collective, collaborative action around addressing these issues.
Yeah, and also if I may add, from the ECLT perspective and experience, also we have seen that tackling hazardous child labor also needs to come from government. So, as you were mentioning earlier, Colleen, within the UNGPs and the respect, protect, respect, and remedy guidelines. It's very important also to create that relationship with the government, and in that sense, the foundation has liaised with many countries on creating lists of hazardous tasks, creating national action plans as well, and establishing memoranda of understandings with the government and with the companies, so it can be a more holistic approach to the issue.
Yeah, that's great. Are there any other questions?
You can also raise your hand and ask your question live if you want to. Otherwise, this webinar is going to be, the recording of this webinar is going to be uploaded to our social media and our e-learning platform. And Rory was saying that we're going to share also the slides afterwards, so I can share the recording with the slides after the webinar. Also, we wanted to invite you for our next session, which is going to be in collaboration with the University of North Carolina on how farmers can be helped to manage stress, because we have seen that the suicide rates in the countries where we have programs is very high for farmers. So we thought it would be interesting to address mental health issues. And that's going to be on August 29th, 2024. So yes, stay tuned for the invitation for that webinar. I really want to thank Colleen and Rory for your insights, for your expertise, and for your time. And thanks to all the participants, and looking forward to seeing you soon.
Thank you very much for having us. It was a pleasure. Thank you.
You.
Have a good afternoon, everyone.
You too. Bye. Thank you.
Bye.
Bye-bye.